all the courts that have worked, including the anti-corruption where I'm now working. And I relate very well with the staff and with the peers. And I'm one person who is easy when it comes to relating with people, and especially when it comes to matters of work, because I believe teamwork is very, very important. And without teamwork, we cannot be able to achieve much.
I think now we are getting to the other technical area of how you work with other people in the Court of Appeal.
Yes.
Let me hand over to Commissioner Mwanza to take it from there.
Thank you, Judge. Under the Work Injury Benefits Act,
Yes.
I think of 2007,
Yes.
matters that arise out of work
Yes.
injuries are heard by somebody known as the Director of Occupational Health.
Yes.
He exercises some judicial powers in assessing, injuries and then awarding damages.
Yes.
Judge, would you be aware how those decisions are enforced?
Thank you very much, Commissioner. The decisions are enforced by the ELC court.
Yes.
Such that once now the matter has been
ELC or
no,
ELRC?
sorry, ELRC.
Okay.
Yes, ELRC court.
Yes.
So that once now they have been heard, then a party moves to court for enforcement.
Okay.
Moves the court so that the whatever decision has been made or award, it can be an order of the court for purposes of enforcement.
If there is no appeal
Yes.
from that decision,
Yes.
what will be the procedure of enforcement?
Sorry.
If
Come again,
you see
Commissioner,
there is a right of appeal
Yes.
to the ELRC
Yes.
from those decisions.
Yes.
However, if there is no appeal
Yes.
and parties are satisfied,
Yes.
how would they enforce it?
I'm not very sure, Honorable Commissioner, but I think they move to court for purposes of the enforcement.
Okay.
Yes.
All right. Thank you.
Yes.
Now, the second question I want to ask is about you've read dinner management.
Yes, I'm aware of it.
You're aware of it.
Judgment, yes.
All right.
Yes.
Now, there is now a recent decision by the Supreme Court,
Yes.
Standard Chartered versus Manchester Outfitters.
Yes.
And I want to read you a paragraph, I think paragraph 64 of that judgment,
Yes.
again from the Supreme Court.
Yes.
It states that a purchaser intending to buy land, that's at paragraph 64, a purchaser intending to buy land is bound not only by the principles of caveat emptor, that is buyer beware, or nemo dat non quod non habet, that no one can give what they do not have, but also by the torrens principles in due diligence. Now, it then says that by looking into the details of the register, one would see the status of a charged property. Now, when you look at that judgment, in your view, would you say that it is in consonance with Dina? Because Dina says, look at the root of the title. This one says, your due diligence is through the torrent system. Examine the register.
I would say that it is not in tandem with Dina, because in Dina, the Supreme Court stated that you go beyond the title and do due diligence, including going to the ground and doing the due diligence,
Yes.
rather than what you find in the title.
Yes.
And the Supreme Court stated that the title can, the title alone, the paper that is the title, does not give you a legitimate title to land just because you have the title. How it was acquired initially by the first person who was registered, or how it was acquired, is what is most important.
Okay.
Yes.
Now you understand these two principles.
Yes.
Now you have a matter that comes before you,
Yes.
as a court of appeal, and it's with respect to a purchase through an auction.
Yes.
So, and you know, at the point of where you are auctioning, where a bank is selling a charged property, the auction happens at the fall of the hammer.
Yes.
And the appellant says that, you know, before the bank charged this property,
Yes.
there are certain issues that go to the root of the title.
Yes.
And the appellant says, well, that might be the case, but if you read Manchester Outfitters,
Yes.
I was just required to conduct a search because I had a very short, you know, interlude to do a search and be at the auction to buy the property at the fall of the hammer.
Yes.
And because the bank had other duties in charging that property, then there was no requirement for me to go beyond
Yes.
what the bank provides.
Yes.
That's number one. Then number two is, would this be a case that you would consider in terms of clarity to the law,
Yes.
that the interest of commerce are such that banks ought to be protected, so that when they get properties and charge them and advance monies, then those that buy should not be doubtful about the root of the title.
Now this now brings to focus the different interpretations in Dina and Manchester.
Yes.
Because now here you are told which of the decisions to use.
Yeah.
If I was sitting in a matter like that one, I would go by Dina. And I would say that the root of a title is what matters. Because if we are to leave it to the title itself, and we say that once you have the title, it doesn't matter how it was acquired, then that would mean that I will be propagating issues of rat grabbing. And then somebody would be coming and giving it as a defense. And I agree, yes, there are commercial interests to be taken care of for the bank. But the bank is also supposed to do its own due diligence when they are charging this property, so that even as they commit their money by advancing loans to the parties, they should also be satisfied that the title that the client is leaving as security, it is a legitimate title. So
then how would the appellant,
Yes.
the respondent,
Yes.
mitigate their loss? Because one, they've gone to the market,
Yes.
you know, an auction market. They've bought a property.
Yes.
You said that is, you've declared, for instance, that it's a bad title.
Yes.
And maybe this is at a point whereby there's been a bit of litigation back and forth. By the time it's in court, the respondent probably has taken possession.
Yes.
And has done some development.
Yes.
So how do you balance this competing interest, and what will be the remedy now for a respondent?
Yes.
I know the case is for the appellant,
Yes.
but in this case, where is the justice?
Justice does not have to be fair to all the parties.
Okay.
And when it comes to the law has to be applied, and
Yeah.
it has to be applied uniformly to all the parties. And in this case, if we are to leave it open, that once I have the title, that is the end of it all. Like I've said, it is going to propagate so many cases of rat grabbing, and even people, rat frauds, by people, because somebody will be saying, once I go to court and I have the title, that is all. So I would insist that the decision in Dina, it's good law. And that is what I think, if I was faced with a situation like that one, I think that is what I would use.
Okay.
Yes.
Now, you've also read the decision of the Supreme Court on Murwatetu and the subsequent decision on sentencing.
Yes.
Would you agree with me that those decisions address mandatory sentences? For instance, with respect to murder, and
Yes.
the subsequent one on, or the subsequent ones on sexual offences.
Yes.
Now you have an issue an appeal that comes before you.
Yes.
With respect to sentence for manslaughter.
Yes.
A judge has looked at all the circumstances, has given this sentenced this mother, who was one, pregnant, about 8 months pregnant, and two, has 2 other children who are minors. One is 2 and another one is 4.
Yes.
And then she appeals on the sentence. Would this be a case whereby now, under I think the powers of the Court of Appeal, you can interfere with the sentence as being harsh, or you would consider the interest of the 3 children, the 2 children, one who's 2 years, another one who's 4, and this mother is pregnant, and then revise and grant an uncustodial sentence?
Yes, thank you, Honorable Commissioner, for that question. I've read the decision of Murwatetu, and I've applied it in many instances, and under the as guided by the Supreme Court, that it only applies in murder cases, and it touches only on Section 203 and 204 of the Penal Code. But now, here being a case of manslaughter, and this person maybe has pleaded guilty to a lesser charge of manslaughter, or maybe after the court has heard the matter, has found that the elements of murder are not proven, and has reduced the case to manslaughter. I would first consider what were the mitigating factors, because the purpose of the mitigation is for the accused person to tell the court the special circumstances that the court should consider in sentencing, so that it does not, it exercises the discretion in their favor and imposes a sentence that is lesser. So I would look at what were the mitigating factors. There are times that you look at the mitigating factors, and then the court may exercise its discretion. I would want to give an example. There is a matter that I did in Embu. It was a murder matter. It was, of course, after the Murwatetu decision. And this lady had murdered the husband. I found her guilty, so that's why I'm saying she had murdered the husband. And the mother-in-law had passed on. The father-in-law was in court, a very old man, and this lady had 5 children. And during the sentencing, they all came to court, and they cried throughout in court. And they said, now, if you put our mother in jail, we are all going to die. And there was even evidence that during that time, when she was in custody, this lady, the big girl was being sexually molested, because they were staying without somebody to take care of them. The father-in-law also pleaded with me, because he said, now, if you take her in, we all depend on her. So I listened at the mitigation, and I gave a sentence that I thought, but I considered all that mitigation. So that is why I'm saying in this one I would consider the mitigation. I would look at how was the offense committed, because also how the offense was committed also has a bearing. Was it in a ruthless way? Did this person the circumstances generally of the offense?
Okay.
And if I find that there were no aggravating factors, I would exercise my discretion taking into account the best children, the best interest of the children. But of course, I'll have to punish her for committing the offense. But I'll be guided by that.
Okay.
Yes.
Thank you, CJ.
Yes.
Thank you, Honorable CJ. And Judge, once again, welcome.
Thank you, Commissioner.
I'll take you to the issue of judges' remuneration and benefits. Under the Constitution, these benefits and remuneration for judges, as opposed to state officers like members of parliament, are drawn directly from the consolidated fund. That is, they are a direct charge on the consolidated fund. Why do you think it's that way?
Thank you very much, Honorable Commissioner. Judiciary as created under Article 160, Article 160 of the Constitution talks about the independence of the judiciary. And there's a reason why that chapter is there in the Constitution. And when you look at that chapter, it sets out, it itemizes the different protections or the different aspects of the independence of the judiciary. And one of it is that when a judge is hearing a matter or making a decision, they should be guided by the Constitution and the law, and they should not be under influenced by any other person. And the other one is the benefits of a judge should not be interfered with or should not be varied even after he retires or when he's in the office. The other one is that an office of a judge cannot be declared vacant when there is a substantive order of that office. And now, the one now, Honorable Commissioner, that you have said that the benefits of a judge cannot be interfered with, and the salary of a judge should be charged from the consolidated fund. And I think why the Constitution infers that is to give a judge independence, because most of the times we deal with matters whereby we have to make adverse orders against state organs, against the government, and in a situation whereby the executive may feel that the judge has not made a good decision. I mean, have made a decision against them. Then a judge may be disadvantaged by not being assured that the salary is there, or even the judiciary as a whole. And I think that is why the benefits were infused, so that they can protect the independence of the judiciary.
Okay, yes. Thank you. And lastly, just another question still on the Constitution. Cases of a state of emergency. A state of emergency is declared in Kenya, there's a scenario, and consequently, a legislation in relation to that through that declaration is passed in Parliament. So you have a state of emergency, and then you have legislation passed. Now, will the High Court have jurisdiction to determine the validity of that legislation, or consequently will the Court of Appeal have jurisdiction on appeal to determine the question of the validity of that law?
Yes, thank you very much, Honorable Commissioner. A state of emergency is usually declared when there is insurgence on where the security of the state is threatened. And the provision, the article in the Constitution, if I'm not wrong, is Article 58 of the Constitution. whereby which allows declaration of emergency and extension. That article provides for declaration of emergency, how it can be extended by Parliament, and for how long. And the first extension, it cannot be more than...
Just to
yes,
save time,
sorry.
to
Yes.
save on time,
Yes.
just go to the question
Yes.
about the legislation.
Yes, about the registration.
Yeah.
Yes, that is what I was coming to, Honorable Commissioner. During that time, any registration or any action that has been taken in consequence of declaration of emergency can only be handled by the Supreme Court. The High Court does not have any jurisdiction to decide any questions to do with the declaration of state of emergency, extension, or any registration, or any action that may be taken during that time. It is only the Supreme Court.
There are instances, I think there's a time when the Supreme Court has rendered that anything to do with validity of the Constitution, constitutional interpretation, and all that must start at the High Court.
Yes.
Why is this an exception?
Thank you very much, Honorable Commissioner. The jurisdiction of courts is is donated to it by either the Constitution or the statutes. In this particular case of declaration of anything to do with the registration during state of emergency, it is specifically provided for under Article 58 of the Constitution.
Okay, it's okay. I think I'm satisfied. Thank you, Honorable CJ.
Yes.
Yes, good afternoon, Judge.
Good afternoon, Honorable Attorney General.
Yes. Did you say that in the year 2024-25 you are the best performing court?
Yes, 2024, no, 2023, 2024, no, 2022, 2023, 2023, 2024. Those 2 consecutive years.
So let's go to 2023-2024.
Yes.
How many judgments did you write?
Unfortunately, I cannot remember how many I wrote. I'll have to check on that after this.
Do you know the basis of your being the best performing court?
Yes.
What was the basis?
One of it was merit productivity.
Yes.
Then the other one was delivery of judgments within 60 days.
Yes.
The other one was delivery of judgment on the first on the first time when it comes up for delivery.
Yes.
Then the running of the registry. Yes, these are some of the and the case clearance also.
Are you in a position to tell me, out of the cases you handled in 2023-24,
Yes.
how many of them were accelerated to the High Court?
To the High Court.
Yes, to the Court of Appeal.
To the Court of Appeal. I checked with the Kenya law from 2022.
Is there a way that you can know
Yes.
how many cases emanating from your court
Yes.
were accelerated to the Court of Appeal?
Yes, from 2022 to date were 50 matters.
2023-2024? Or
2022
2022 to date?
2022, yes.
50 matters.
Yes.
Out of those ones, in how many were you reversed and how many were affirmed?
12 of them were reversed.
How many?
12 of them.
12.
Yes.
So you were affirmed in 38.
Yes.
And what have you done about the ones, what have you learned from the ones where you are reversed?
Some of the I usually read the case back, and I'm able to see where I went wrong, and I even have some judges of the Court of Appeal who peer review me, so that if my judgment have been upheld and I'm not able to understand well, I reach out to the bench, and I would like to understand why. One of it, which I can remember well, because some of them comes many years after, was on damages that had awarded. But the overturning was just not on liability, but it was on the amount of the damages that...
Using the current performance management system,
Yes.
is there a measure with regard to reversibility or confirmation of cases by the Court of Appeal?
I'm not aware of any, because all what they do is...
Which other qualitative method exists in the performance management system that we are using now, which is non-numerical?
At the moment, we don't have any qualitative.
Thank
all
you.
what we have is quantitative.
All right.
Yes.
Second question.
Yes.
You've interacted with arbitration, have you?
Not much.
Not much.
Yes.
But you can answer something about arbitration. Can you?
Depending on what it is.
All right.
Yes,
So
I can give it a try.
arbitration is founded on party autonomy,
Yes.
yet Kenyan constitution law requires decision-making to be consistent with public interest and fundamental rights.
Yes.
In your view, at what point does public interest limit or override arbitrability, particularly where a dispute is arising from a private contract that raises human rights or constitutional concerns?
Do you mind coming back again on that? I didn't understand the question. Can you
Arbitration
repeat? Yes.
is founded on party autonomy.
Yes.
Yet in Kenya, when we're interpreting law, we take into account, our decision-making takes into account the provisions of the Constitution
Yes.
and public interest
Yes.
and fundamental rights.
Yes.
So sometimes, public interest may limit or override arbitrability of a case.
Yes.
How would you deal with those concerns when the dispute is arising from a private contract? It's arising from a private contract,
Yes.
but it is touching on issues to do with human rights and constitutional issues,
Yes.
which are not very personal.
Yes, thank you very much, Honorable Attorney General, for that question. Yes, it is true that
Can I just repeat again? When the subject matter
yes,
of arbitration,
yes,
although it has come as a private person concern,
yes,
but it has got public interest connotation.
yes,
Yes.
yes. Now that is where the public interest comes in, and that one now will invoke the public interest and fundamental rights, such that the private interest cannot supersede the public interest. And if in such a case then, and especially where public resources are concerned, and where a majority of the citizens are suffering as a result of the transaction, then the public interest is invoked, and therefore the interest of the private interest vis-a-vis the public interest supersedes. I don't know whether I've been able to answer that question, Attorney General.
Yes, you have tried. What I wanted to solicit from you is that
Yes.
the mere presence of human rights issues
Yes.
may sometimes render a matter non-arbitrable. Sometimes.
Yes, it may.
But should it be a consideration, and if yes, to what limit?
Yes, it should be a consideration. Because looking at even the Nyutu case, the issue of public interest came in, and it was on that basis that the Supreme Court of Kenya opened a small room. A small room for awards for the Court of Appeal to entertain the awards, because that is one of the considerations that. If the award is against public interest, and if there is some injustice in it, so therefore public interest, when it kicks in, it overrides private interest.
So will the court be relying on the nature of the rights violated or on the remedies?
It should rely on both.
The nature of right and the
Yes.
kind of remedy sought.
Yes.
Okay.
Yes, that is my view. And like I've said, I've not interacted with arbitration a lot.
We are all trying, we are all learning.
Thank you.
Thank
Thank you, Honorable Attorney General.
Thank you, Honorable Chair. Judge, one or two questions.
Yes, Honorable Commissioner.
If you are the successful candidate and you join the judges of the Court of Appeal, you'll find that we grapple with many things,
Yes.
touching on the law. And one of the issues that we grapple is the question of a life sentence.
Yes.
What is a life sentence? How long is a life sentence?
Thank you very much, my lady, Honorable Commissioner. Life sentence is a form of sentence in Kenya, and which is provided for in the statute. But this has been a subject of debate from the time the Supreme Court dealt with the Murateto case. The subject of life sentence has been subject of litigation in the Court of Appeal. And I'm aware of the case of Ayako, and some other decisions by the Court of Appeal, which have limited life sentence to a number of years. Like the Ayako case, the Court of Appeal defined life sentence to mean 30 years. And as I've said, there has been a debate around the life sentence. But my position in this is that, and being guided by the Supreme Court in the directions that the Supreme Court gave, is that life sentence is life sentence as it is provided for in the law. And therefore that means that it is a balance of your life as long as you have been in prison. And since we have been guided by the Supreme Court that we should not interfere with mandatory, minimum mandatory sentences that are provided for in the law, I would take it that life sentence in our statutes means the balance of your life as at the date you are sentenced for life sentence.
All right. The Constitution, of course, guarantees us equality.
Yes.
So you have a person who is 75 years old and is sentenced to life.
Yes.
And you have a young adult who is 20 years and is sentenced to life imprisonment.
Yes.
So, in view of what the constitutional provisions, particularly Article 27, would you then say that the law has been discriminatory, or it has treated both these persons, the one of 75 years and the one of 20 years, without discrimination?
Thank you very much, my lady Commissioner. Equality as provided for under Article 27, I would, and taking it in view of the life sentence, I would not say that it is discriminatory, because the issue of the life sentence and at what point you commit the offense, that is what is important. Because now we cannot say we are going to apply equality when it comes to matters of life sentencing, just because you committed an offense when you are older and somebody committed when he was younger. The law should apply uniformly, and I think that that would not be taken to be discrimination, because there is no time. There is no time set out in the Constitution when people can commit offenses. So if one commits an offense at 80 and another one commits an offense lower than that, and especially if the law provides for mandatory sentences, then the law should apply irrespective of the age.
And I heard you say that the law is not about fairness. Is that why in other quarters they say the law is an us?
Yes.
Did you say that? That the law is not about fairness?
I agree, Honorable Commissioner, because sometimes the law is not about fairness. It is about what is right. Such that in that question, that's why I've answered it that way, because for me, there is no discrimination, and the issue of equality will not have a space when it comes to mandatory sentences.
But on the face of it, and I'm sure in your career as a judge,
Yes.
you've had occasion to visit prison,
Yes.
and you've seen very old people who are serving life sentence. They're just
Yes.
waiting to die.
Yes.
And you've also seen young people who are also serving a life sentence, and they have a long way to go.
Yes.
You've encountered that?
Yes, I have. I used to go to prisons a lot.
All right.
Yes.
And in your own sense of justice, does it sit well?
I'll give my view here.
Yes, precisely.
Yes, I'll give my view. It does not sit well. Seeing that old man who only maybe have a few years to go, and he's going to spend the rest of his time in prison when he should be enjoying with his great-grandchildren. But now again, also seeing that young boy or that young girl who has a whole life ahead of him, and he'll have to read the rest of his life in prison. But now again, the law is what it is. And with the guidance that we were given by the Supreme Court, as judges, sometimes we have to separate the judge we are and the person and the human part of us. So I would give the sentence according to the law under the principle of stare decisis.
I have no problem with the guidance that has been given by the Supreme Court.
Yes.
And in respect of this question of life sentences, do you know the guidance that which is the case that the Supreme Court gave directions as regards the question of life sentence? Do you know that case?
Oh, the Manyeso case.
Yes, you're right. Julius Kisau
Yeah,
Manyeso.
Kisau Manyeso, yes.
But of course, society keeps evolving. We are not static. And sometimes when we find that there are certain things that really on the face of it are causing injustice,
Yes.
like for instance, have you had occasion to reflect on what happens in other Commonwealth jurisdictions,
Yes.
say for instance South Africa, when it comes to this question of a life sentence?
Yes, I've looked at other jurisdictions, and most of them, and when I was reading the case of Ayako, the Court of Appeal was informed by other jurisdictions, and they cited, I cannot exactly remember, but I remember they were informed by other jurisdictions. Now, the problem that I would find when I am a judge here in Kenya and I'm bound by the laws of this country is to divert,
No,
from-
you are bound, and we are
Yes,
all
I'm bound,
bound by
yes.
decisions of the Superior Court.
Yes.
But here the question I was asking is,
Yes.
any reforms,
Yes.
any recommendations that we could make in this area?
Yes, actually that is where I was going and saying, I think now here the buck stops with Parliament, because it should be the Parliament to amend the Act or to come up with laws that will take care of solutions like those ones. So as judges and as the civil society or even the state organ, the other state actors, then we should be thinking of how to rally Parliament so that they can amend the law, because now that is their jurisdiction.
All right, like for instance, a place like South Africa,
Yes.
where somebody serves 25 years and
Yes.
after that they are put on parole.
Yes.
Don't you think that would be a good recommendation?
It would be a good recommendation, but I would also look at the circumstances under which the offense was committed. And I would say it should be left to the discretion of the judge and the circumstances of the case, but that discretion would help, because each and every case should be considered on its own facts. And that is why accused persons are told to mitigate.
Thank you. That's all, Chief Justice.
Judge. Just going back to Moroatetu,
Yes.
when the Supreme Court declared the death sentence unconstitutional, they then opened the door for resentencing of those who had already been convicted and sentenced to death.
Yes.
What are some of the mitigating factors we ask the courts below to guide them in terms of resentencing? What did we ask that they look at?
Thank you very much, my Lady Commissioner. Some of the guidelines, the Supreme Court started by saying the resentencing should be done on a case-to-case basis, and mitigation sentencing hearing should be done so that the prosecution and the accused person can be heard. And some of the considerations are the circumstances under which the offense was committed. Because those are aggravating factors. Actually, it's the aggravating factors. What were the aggravating factors? And then if it is an offense that was committed in gender violence situation, whereby a party was being violent to the other, then the Supreme Court also gave directions that when all cases that were heard, or all those who desired to be heard on resentencing, can move the High Court for resentencing. But when a matter is pending before the Court of Appeal, the High Court did not have jurisdiction unless it was on sentence. Yes, those are some of the guidelines that the Supreme Court gave.
Okay, thank you very much.
Yes.
Yeah, you've mentioned one or two that we set out.
Yes.
The Supreme Court also, again, has set out guidelines. I think the Supreme Court likes to set out guidelines from time to time.
It is the highest court of the land, and we are guided.
On the assessment for mental incapacity, are you aware of the matter that we did?
Yes, I'm aware.
When we have guided courts on how to assess mental capacity, what are some of the things that a court must look at when they are assessing mental incapacity?
Yes, thank you very much, my Lady Commissioner, for that. I have in mind the case of one of our colleagues. I will not mention the name, but I have that in mind. And the Supreme Court gave parameters on how. And one of it is that for the court to come to a conclusion that there was somebody's mental state has made him or her incapable of discharging his or her judicial duties, there has to be a medical report by a medical doctor in that specialized in that area, who would be say to what extent the incapacity has affected her work. Then the party should be heard on before a decision can be made. But that is one of the critical.
Yes, thank you, Judge. It is the correct case.
Yes.
And you have been able to give me some of the guidelines. Thank you.
Thank you, my lady.
Thank you, Chair. Good afternoon once again, Judge.
Good afternoon, Honorable Commissioner.
Are you okay, or you want to take a water break?
Maybe just a bit.
Okay, please proceed.
Thank you. Yes, we can just proceed, Honorable Commissioner.
Please just
It's
take
okay.
the water. Yes.
Yes, because it's refusing to open, and I thought I'm taking
Grace,
so much
kindly
of your
proceed.
time.
No. I am a human rights practitioner. So
Thank you,
want you to
considering
be
that you have
comfortable,
been
yes.
seated here since morning.
yes,
Thank
so
you.
if you need that
Thank you.
water.
Thank you. I'm now okay.
Ah,
Thank you for
great.
that indulgence.
Okay. Judge, you presented 5 sample writings that we had requested, and one of them was your thesis for LLM.
Yes.
You are well grounded on the law,
Yes.
and you demonstrate consistent ability to identify core issues, apply legal principles coherently, and reach well-reasoned conclusions anchored in law, and you use relevant precedents well.
Yes.
The tone is measured, calm, and impartial, reflecting professionalism. So good job when it comes to your sample writing that you presented. Among the document you did present is your LLM paper on judicial performance,
Yes.
and you did a comparative analysis
Yes.
with what is happening in Bulgaria and Arizona in the US.
Yes.
I know the conclusions of the paper didn't really touch on what the JSC and maybe the CJ or the PJ ought to do when it comes to performance management, but I'll just ask you a general question around judicial performance.
Yes.
So for Bulgaria, your paper says that judicial performance is directly linked to appointments, promotion, and disciplinary control.
Yes.
And in the US, you mentioned that the process is public-facing,
Yes.
where individual performance for judges is shared with the public, and public are allowed to give their views on the same.
Yes.
Currently, a High Court judge is expected to deliver 110 rulings and judgments per year. Is that factual?
Yes, that's factual.
And at times, judges are not able to get to that target.
Yes.
I have seen some reports where there are those who are even at 5 and at 20.
Yes.
Would this amount to incompetence? If you're expected to deliver 110 and you deliver 5 or 20, can that amount to incompetence? That is question number one.
Mm-hmm.
And what would be the role of the PJ or the President of the Court of Appeal, the CJ or the JSC
Yes.
in promoting accountability when it comes to judicial performance?
Okay. Thank you very much, Honorable Commissioner. Yes, it is true. I did a paper on performance management. And this is because before I joined the judiciary, I was in very active practice. And there are times we faced a lot of frustrations from the courts. That time, you come to court, a judicial officer is not there, a judge is not there, you sit all through, and eventually the court assistant comes and says, go and take other dates in the registry. But I must admit that judiciary has done very, very, very well. The judiciary that we knew those many years is not the same judiciary. And I thank the Honorable CJ and this commission because of the good work that you are doing. Because to be honest, judges are working and even the courts are working. But now, to answer your question, yes, I know the output of a judge should be 110 matters in a year. But some are able to get to that point, others are not able to get that point. I would want to look at it from two different perspectives. First, three. Actually, let me look at it from three different perspectives. First, cases are all not the same. The nature of cases that we handle are not the same. For example, I'm now sitting in the anti-corruption court. The kind of cases that I handle are very, very different from what I was handling in Embu and what I was handling when I was in the civil division. In terms of complexity, in terms of documentation, and even in terms of the number of witnesses. You find that a matter has 15 defendants, each has a lawyer. So by the time you are done with one witness, it will take so much time. Sometimes you can have one witness in the witness box a whole week. Now, compare this with any other station, maybe that does not have matters that are voluminous and complex. A judge in another station would be able to, in that week, when I'm hearing that one witness, a judge in another station has been able to deal with 20 matters and has been able to complete, because maybe the witnesses are short and there are not many. That is one of them. The special the special nature of the cases that we deal with. That is one of them. Secondly, the other one is that, and here I want to be very, very honest, that some of us are not outputting. I don't know, and it could be maybe as a result of challenges. There are some who may be having challenges. There are others who may not be having challenges. But we are not all outputting the way we are supposed to output. And this is maybe for different reasons. The infrastructure that we have may not be the same. There are some areas whereby network is a problem. And generally, people are different. There are those who want to give it all, create time, more time than you should sit. Some of us sit during vacation. We take 1 week during the vacation. So there are so many factors that contribute to that. So therefore,
Judge,
I would not say it is incompetence.
So sorry, if you
yes.
get to now the point number 3,
yes,
where all resources are available, you have similar cases in terms of waiting.
yes,
You're in the same division, you're in the same station,
yes,
but one appears to be carrying more than the other.
yes.
Wouldn't that flag out something, that all matters remaining constant,
Yes.
you're not carrying your weight?
Assume
you have.
Yes.
Shouldn't that be a concern for Kenyans, for JSC, for PJ, for CJ, and the judge, him or herself?
It should actually be.
So what role does the PJ, CJ, JSC?
Yes.
And the other day we attended a parliamentary meeting, the CCIO meeting, and they said they want to see individual judges' performance.
Yes.
Yes. What is your thought on that?
My thought on that is, one, to begin with, there should be a way of measuring a judge's performance as a person. And especially in stations where there are more than one judges. When I was in Nembu, I was the only judge, so whatever performance that was there was for me and my team. The people at the registry, and especially now at the High Court, the people at the registry. But there are cases where you find there are many judges in a station, and some are not outputting as they are supposed to do. I should believe, because performance is part and parcel of what I like doing. I mean, something that I like. That the PJ should even be able to write to a judge and ask a judge, why aren't you inputting? So that it may not be to punish the judge, but so that he can be able to know if the judge has any issues, or if the judge is encountering some problems, and that is why the judge is not performing. Once now the judge has answered or has responded, then if the Honorable PJ looks at the answer and sees there is actually no good reason why the judge has not performed, then there should be some measures that should be put in place. When you look at the thesis, my project, I've flagged that out as one of the problems that we have, that there are no sanctions, okay? And there has been a debate because of this issue of independence of judges. But I'm one person who has been saying, yes, independence is there, but then we should perform. So I think we don't have sanctions. And I think that is why when a judge is not outputting, and he or she is not giving good reasons why, then something should be done. And I think
okay, the role of because of time. So the role of CJ and JSC, so that maybe just clarify.
Yes.
To the issue of performance.
Yes, the role of the CJ. One of the problems that the Honorable CJ and this commission may have in enforcing that is because we do not have a regulatory framework, legal regulatory framework for the performance. And the only place where performance is mentioned is the Judicial Service Act, the High Court Organization and Management Act, and the Court of Appeal. And it is just mentioned in passing. Okay. So I think the starting point should be we should have a regulatory framework, a legal regulatory framework, so that when the JSC or at least there'll be a law regulating. Otherwise, sanctions, in my view, should be there, but within the law.
Okay. Lastly, femicide in 2024 there was a 75% increase of femicide cases in the country.
Yes.
And the president has set up a task force to establish the causes and find a way of how these cases can be reduced.
Yes.
What is the role of the judiciary in addressing this vice in the country?
Thank you very much, Commissioner. The role of the judiciary can have many roles. Because the Honorable CJ's blueprint of STAG, we should now move from the courtroom so that we go to the communities. And one of the things that we should be doing is to educate the people on the law and where they can get assistance or remedies. And once we do that, first they should be able to know what do I do when a case like this, or if I'm a victim, or if a relative is a victim. Then the judiciary also, we should also be active by, now that there's a task force, then we should give our views as the judiciary on what could be causing and what can be done about it, with a view to reducing the incidences of femicide. Then when these matters come before us, then we should ensure that we do we should give punishments that talk to the fact that we are not, we are condemning it, but of course within the law.
Okay.
Yes.
So picking your last feedback on your role in handling such cases, yes. You did handle the case of Republic vs. Boniface Yakulula. You remember the matter? Where a young man was accused of killing a 25-year-old girl in Embu, a church setup. Are you the one
the university girl? I handled a number of matters.
Cases. Okay, there is that matter.
Oh, the church.
Yes, the church.
Oh,
matter.
The Catholic Church. Yes, I remember
church.
it. Yes, I
so
remember it.
So the young man actually confessed.
Yes.
And he confessed to killing, to raping, torturing the victim, killing her, stealing the phone, and disposing the body in a pit latrine. In other jurisdictions, this would amount to aggravated murder.
Yes.
And in this case, you did sentence the young man to 15 years imprisonment.
Yes.
There was hue and cry about the sentence, including the NTV. He had it out. There is this murder tapes, and Brian Obuya was able to highlight. And reading the comments in Brian Obuya's piece on YouTube, you can tell Kenyans were asking themselves why such grievous case, why would it only attract 15 years? I know you have discretion, but the sentencing guidelines requires you to look at the nature of the offense and met the appropriate sentence. So based on the judiciary sentencing guidelines and the role of criminal law to deter similar cases, do you think you may have done something different in that matter?
Thank you very much, Commissioner. Let me start by saying, when this matter came before me, it did not go for full trial. The state and the accused persons pre-bargained. and they entered into an agreement, a pre-bargain agreement that was filed in court. So as of the time I sentenced, I may not have had all those facts, and since the prosecutor and the accused person had agreed and they had pre-bargained, if maybe I had had the whole case, and if those facts had come out during the hearing, I would have maybe given meted out a different sentence. But when parties agree to pre-bargain, us as the courts, we under the impression that the prosecutor is taking care of the interests of the deceased on behalf of the family, and therefore sometimes we may not be aware of the full facts.
But you get a report of everything. You just don't get the plea agreement. You get the information about the entire
Yes, the pre-agreement, they bring the pre-agreement, but the pre-agreement does not set out all the facts. It just captures just a few areas that we have agreed to pre-bargain, and these are. But the whole circumstances of the case are never brought to the judge.
Are you sure, Judge, about that?
Yes, I'm sure. I'm sure. I'm sure about that. You see, when you hear a matter, you are able to appreciate because the evidence has come out, and you have listened to the witnesses. But when it is pre-bargain, sometimes we are not put into the picture of all the facts the way they are. So sometimes they are disadvantaged.
Facts are supposed to guide you in sentencing.
Yes, they're supposed to guide me, but the facts usually are so sketchy. And I wish, Honorable Commissioner, you can look at that file. The facts were very sketchy. So I did not know the circumstances, the full circumstances when I sentenced. If I had known, maybe I would have imposed a heavier sentence.
Okay, thank you. Thank you, Chair.
Yes.
Yes, sorry, Judge. Part of this is schooling also for us. So you would find a murder case of that nature attracting 15 years.
Yes.
And now the Romeo and Juliet situation attracting life imprisonment, yes, or 22 years and above.
Yes.
How does that now settle in our minds? Who actually tortured, raped, nakatakata na kuweka toilet.
Yes.
And then the one who lives with the child and the wife, yeah, although she's below 18, she's 17. But now the husband or the one who is guilty of having married a youngster ends up in life imprisonment. How do these settle in your jurisprudence?
Yes, thank you very much, Honorable Commissioner. I agree with you, and the concern is actually very, very varied. But like they say, when a judge sits there, there are so many things that you may not be aware of. Sometimes actually we have to keep praying for spiritual discernment, because sometimes all the facts may not come out. But like I've explained to Commissioner Ngutia, if I had known the circumstances of that case, maybe the sentence would have been different. But I agree with you, and the law should be seen to apply fair. It should be fair to to everybody, and it should be applied equally. But like I've said, sometimes we are disadvantaged. We may not be able to have all the facts. Yes, and in pre-bargain, one of the considerations when you are sentencing for a mitigating factor is the fact that somebody pre-bargained and he saved the time of the court. So when now a pre-bargain comes and you honestly believe that the circumstances were that it was not intended, then you are guided by the sentencing policy. Yes.
Thank you, Chair. Good evening, Judge.
Good evening to you.
Yeah, imagine
Commissioner.
it's now evening.
No, I'm sorry. I'm sorry
Okay.
if I've really been sitting the whole day.
Actually, I was feeling for you, but it's okay. All of us have been sitting.
Thank you.
You've been extensively examined about performance.
Yes.
And the performance appraisal system that we have. I don't think I want to belabor the issue with you. You've already shared with us your insights on the subject.
Yes.
I just want to discuss with you your performance report from DISPOP. I believe you've got it.
From?
You are served with a copy from DISPOP,
Yes, I was served
the
with a
Performance Directorate.
From DISPOP?
Yes.
No, I was not served with a copy. But,
Before this interview, you are not furnished with a copy
no,
of
I
your
was not
performance
furnished.
report.
I was not furnished, but I went through the report and I picked out. I was not served with
You mined it
DISPOP.
through the CTS? Or where did you get your report? The one you went through?
Yes, through the CTS.
Through the CTS,
Yes, through the
okay.
CTS, yes.
Okay, so Judge, I've always known you to be a hard-working judge, very passionate about performance and even
Thank you.
your job as a judge, or rather your role as a judge. And I think your performance is actually borne out, and especially the period you made reference to. You said 23, 24?
Yes, 22, 23, 23, 24.
Yes, I can actually see from the report that you did quite well. I remember earlier the AG had engaged you on that and you said you didn't have the figures.
Yes.
The figures look quite impressive. But my concern now is that it seems like you have dipped. There's 2 of you in your division.
Yes.
And from the report I have, the expected resolution rate from you was 67%.
Yes.
Out of the 43 cases that were resolved in your station, you have resolved, the ones that were resolved by you are 29.
Yes.
So they are saying you've done 50% only.
Yes.
Though I think there must be a challenge, there's a mistake here, because if you are 2, you are supposed to be 50-50.
Yes.
I don't know if you had picked this out from the CTS.
Yes, I had picked it, but I want to explain, and I knew that question would come, because my performance and what now I'm doing in that corruption court, you cannot compare at all. And some of the reasons I've given, I've already talked
Yes,
about
you
them
highlighted
because
some.
of because of the complexity of those matters, such that you find a judge in that corruption court sits maybe more and longer hours than a judge in other stations.
Actually,
But
I
by
made
the
a
time-
mental note, sorry to interrupt you.
Yes.
I heard you and I appreciate that because it transcends also in the magistracy.
Yes.
The magistrates in the anti-corruption court,
Yes,
you cannot
true.
compare their work output to the rest of the courts.
True.
But I was just wondering, because I made a mental note to ask you this.
Yes.
What kinds of cases do you handle at the anti-corruption division?
Okay, at the anti-corruption division, we handle criminal appeals from the special magistrates court, not only in Nairobi but across the country. Then we handle civil cases as asset recovery.
Okay.
Yes, by EACC and by ALA, Asset Recovery Agency. Those are actually our main cases. Yes. And now when it comes now to hearing of those matters as civil, they are actually quasi or whatever, so that we have investigating officers coming to tell us the investigation. So the witnesses are usually very, very lengthy, and the volumes of documents. You find that one folder can have like 20 or 30 folders. And actually, when matters are coming up in court, the lawyers usually have to call our court assistant and say, I'm referring to this volume, because you cannot be able to carry all the volumes in court. So that by the time you have had one witness, a whole week has gone. And as a result of that, and because we know we get disadvantaged by the fact that somebody may think we are not working, we have developed a card whereby once I sit, the card will indicate what time did I start, what time did I go for tea break, what time did I come back, such that a whole day you can sit a whole day and you have not even finished examination in chief. Yes.
So you have a sort of clocking in system.
Yes, kind of.
Oh, okay.
Yes.
Now, in your view, because clearly the framework that we are having does not reflect your output, especially for courts like yours.
Yes.
How do you think we should improve the appraisal system that we have? What are the factors we should take into consideration?
Yes, the factors.
Other than, of course, the complex nature of the case, as you've already given.
The factors that you should take into consideration is how much time has been spent in a file. Because in a station, for example, like Embu, when I was there, you could even hear 3 matters one day. If it is a succession matter and we are taking FIFA force evidence and the witnesses are short. But now, in the anti-corruption, it is very, very, very difficult even to finalize, unless those ones where by asset recovery, where we hear them by submissions, and it is in very, very, very rare cases. Because you see, matters of documents, it is difficult to finalize them by way of submissions. So I think one of the things that should be done is to consider, even look by going to the record, how much man hours did the judge put in this matter? Because I think that is important. And for example, we only list 1 matter in a day for hearing. And that I found it as the practice when I joined. And I was wondering, why would you list only 1 matter? But then after some time, I understood. And the decision was arrived at by the bar and the bench. Because even that 1 matter, you cannot complete it in a day. So there are those special considerations.
Okay. Thank you, Judge.
Yes.
And I wish you well.
Thank you.
Thank you, Honorable Chair, and good evening again, Judge.
Good evening, Honorable Commissioner.
You spoke very passionately about your integrity.
Yes.
And said it is actually in your DNA.
Yes.
This appears to be affirmed by the stakeholders who gave feedback.
Yes.
When they were asked to give views about you.
Yes.
Which is commendable.
Thank you, Honorable Commissioner.
Now, what will you do if you became aware of corruption allegations against a colleague in your bench?
Thank you very much, Honorable Commissioner, for that question. I've sat in benches, and some of my sample writings, one of it is on the benches that I've sat in. To begin with, I would not expect a judge to be compromised, because a judge should be like the sister's wife. But in the unfortunate situation that I get to know there is something like that happening, what I would do, I would first talk to, it is a very difficult situation. Even before I can talk to the colleague, it is a very delicate situation, because matters of corruption, there are matters where you really have evidence. And even when somebody accuses another for corruption, you will not have any evidence to say this is, and especially when it is a colleague. So it is usually a very difficult situation, and handling it would require somebody to be very, very careful, so that somebody does not accuse you of maligning his or her name. But if I'm caught in those circumstances, I would first want to establish, is it true? Because I would not want to confront a colleague without knowing whether there is some basic element of truth. And if I am able to know that there is some basic element, I would be able to not talk to the colleague in a way to tell him or her that there is this allegation. But I would talk to the colleague in a way and emphasize on the importance of us being fair in that matter and handling it without having to appear. I would not even say that I've had, but without having to appear like we are compromised. But it is a very difficult situation. Yes.
And what measures will you recommend to promote integrity so that it is in the DNA of every other judicial officer and judges?
Matters of integrity are very, very personal because it is a personal choice you make that I will be guided by integrity and against all odds, even if I find myself in a situation where I have to do what I have to take to maintain my dignity and integrity. So it is that personal decision. But I think with the training and so that we can keep emphasizing the importance of integrity, so that people can be able to appreciate, because people don't do these things because they don't appreciate, and that is why I have said it's a personal choice. But we can keep it. The most we can do is to have trainings, invite people from anti-corruption, so that they can come and talk to us about corruption. Yes, so that, and then we identify areas. Like in my division, we have come with what we are calling CRAP. We have soul searched and we have seen what are the areas where maybe invited an officer from anti-corruption, and he took us through, such that now you are able to seal some of those loopholes. But training could help, and then peer review also could help, so that we can keep peer reviewing each other.
Okay, thank you,
yes.
Judge. I wish you all the best.
Thank you very much, Commissioner.
Thank you, Honorable CJ.
Yes.
Judge, a few questions.
Yes.
I'm sure in your daily work,
yes,
sometimes you disagree with your colleagues and the people working directly under you. How do you handle situations where you disagree with colleagues but need to maintain mutual respect and confidence?
Okay. As a reader, especially, there are times that you have to disagree. And a reader has to be careful how you deal with other people, because it is not everybody who would want to do things the right way. So as a reader, it's good to understand the kind of people you are working with, try to understand them, talk to them, because sometimes the misunderstanding would come as a result of many issues. Somebody could be struggling with an issue, and you think that this person is disagreeing for no reason. So it is good to try and accommodate as much as possible the people you are dealing with. Have a listening ear. Then when they disagree, it is also good to know where they are coming from, so that you get to hear them and you get to know why. You may talk to them and you'll be surprised that they have very good reasoning, and they have reasons why they are disagreeing. So it's good to be very patient, to be very tactful, and to be very respectful, so that even when you take it up with them, you do it in a way that is respectful.
Okay.
Yes.
How do you handle multiple tasks with conflicting deadlines?
I am one person who can handle multiple tasks at the same time. For example, at Mirimani, I am the presiding judge of anti-corruption. I am required to hold my meetings of COC, the bar bench. I'm also supposed to supervise the lower courts. And I'm also the chair to the LMT, Leadership and Management Team at Mirimani, do at its appropriate time. And how I do this is I manage and organize my diary, such that the first day of the term, I have a calendar of activities, so that I know what I'm supposed to do, when. But if something comes in between, I am able to create time I am able to go to court up to 4 and have a meeting after 5. And when my diary is not so bad, I am able to convene a meeting within a short time, and especially for staff who are within the building. So it is actually a matter of organizing yourself and having the desire to ensure that you complete as much task as possible within the little time you have. So it is really sacrifice and going out of your way.
Is there room for delegation?
Yes, I also delegate a lot. Like now in our court, I'm with a colleague of mine. When I find that I'm not able to do some of the things, I delegate. Like now, he's the one who is in charge, is making all the decisions. I also use my DL quite a lot, so that anything that need to be done by the DL can do it, or my colleague.
Okay, finally, yes. As a leader and as a people's manager,
yes,
what would you say are the biggest challenges you experience leading the people who work directly under you?
One of the biggest problems that I find is that in every situation, in every institution, you'll find that there are some people who don't want to cooperate. When you sit and agree, this is what we want to do for the vision, so that we can take the division forward, they don't want to cooperate. When you give them a task, they don't want to do tasks. They have no respect. Some will not have any respect for authority, such that even when you want to ask why things were not done, you find that there are no good reasons that have been advanced. So there are all those issues. And then there are also some also liturgies there. Yes, such that you agree in a meeting that we want to have this thing done by this time. But some people have not done it. They do not have any good reason. So there are all those issues.
So how do you deal with those lethargic ones, for instance?
Those lethargic ones, I call them to my office. I would want to know. But before I do that, I first use the DL. I would want to know. I tell the DL, talk to so-and-so. Let us know why this has not been done, or why he's not performing optimally. So depending on what the DL will say, we will discuss with the DL. Then if the DL is able to resolve the issue at that point, that is okay. If not, then I call the person in my office. I would want to know what is happening, why the task is not being performed. Then depending on the reasons that he's going to give me, we can look for solutions together, because this person could be going through problems and I do not know.
Okay.
Yes, but I also encourage them a lot, and I motivate them also. Yes, such that I introduced a reward program, such that we give the best performing staff rewards, monetary. And in Nembu, I was doing that. So they are motivated. We have lunches. Then during our meetings, we discuss the issues. And we agree that we'll work together as a team. So if you are letting down the other staff also will peer review you.
Okay.
Yes.
Just out of curiosity, you have a budget for the reward and recognition initiative? Okay.
Here at corruption, we have not started, but in Nembu we had, such that because we had a budget both for the High Court and the lower court, and the lower court, their budget was bigger, so we somehow we were able to set aside money to reward, because there was competition between registries, the High Court, the lower court, and the ELC. So we could combine resources.
Okay.
Yes.
All right. Thank you, and I wish you well.
Thank you. Thank you very much, Honourable Commissioner.
Thank you. Now, how familiar are you with international and regional legal instruments relevant to your field?
Thank you very much, Honourable Commissioner. I am familiar with some international instruments, but most of the ones I can remember offhand are not in my area. Yes, I may have to check that up. Yes.
Now, conflicts between domestic law and international conventions.
Thank you very much, Honorable Commissioner. Our Constitution, Article 25, allow us to import international conventions and their conditions. But generally, a state is guided by whether it is the principle of monism and dualism. But under our Constitution, international conventions are applicable. International law is applicable, but the conventions are only applicable if they have been ratified in Kenya. So then, depending on which one it's applicable, then you are guided by Article 25 of the Constitution. If we have not ratified, then that means the municipal law takes effect. If it is an international law that is binding, then there would be no need of ratification, and therefore the international law will apply. But where ratification is required by the Constitution, if it is not ratified, then the municipal law applies.
Okay, I'll stop there because there's been a lengthy engagement.
Thank you.
Maybe you are tired.
Thank you, Anna.
Okay.
But
even
you commissioners are tired, and I'm sorry.
Thank you, no problem.
Yes, thank you.
But Judge, you should at least know ANCAC being in the anti-corruption court.
Yes, Honorable Commissioner,
United Nations Convention Against Corruption.
Yes, it evaporated when you sit
on
this.
Which you rightly say it has to be ratified, and Kenya has ratified it.
Kenya has ratified it, yes.
Thank you.
Oh, thank you. When you sit on this seat, sometimes things evaporate.
Yes, in fact, that is the question I wanted to ask you when you said you are aware of international conventions and treaties, but none in your area that you can remember. So I wanted to ask you about the UN Convention Against Corruption. I think it's the same one, Judge. Shishale was asking.
Yes,
you have not had occasion to apply it?
I've not had occasion to apply it, but I know. I know it's. I mean, I know about it. Yes, but I've not had an occasion to apply it.
Okay.
Yes.
We have enough registration anyway. Or
no, we haven't. Our laws are good.
In terms of application.
We haven't.
Yeah, it's been a long day. I think this brings us to the end of this interaction. But before we release you, we always give the candidates the floor also to engage us.
Yes.
And the floor is yours now, Judge.
So thank you very much, my lady, Honorable CJ, and the Honorable Commissioners, for giving me this chance to appear before you. It has been interactive, and I can say that I've enjoyed it. I've enjoyed the interview. When I was coming in, I had my own reservations when I was waiting, so I didn't know what to expect. But I'm grateful that you have surprised me. That it was very interactive, and I thank you for that. I don't take that for granted. Thank you for inviting me for this, and I would want to thank you so much for giving us this chance. But that issue that has been raised by Honorable Ngutia on the policy framework and regulatory framework of the PMMU, I think it is something that maybe can be taken up.
We're actually working on it.
Yes. Oh, thank you.
Support,
Thank you.
Some support from World Bank.
Yes.
We are working on it.
Thank you. Thank you. I'm happy to hear that. I'm happy to hear that. So thank you very much. I know also you have been sitting for the whole day, and it has not been easy for you. And a time like this one, when you have to sit all the day, it is not easy. But may God give you the grace, and may He bless you for the good work you are doing for the judiciary and for the Kenyan people. Thank you very much.
Thank you for those good words of encouragement. We will get in touch with you when we complete the exercise. For now, on behalf of the commissioners, I wish you well.
Thank you.
And, urge you or plead with you to continue doing a good job for Kenyans, because at the end of the day, we serve Kenyans, we serve God.
True.
So all the best.
Thank you.
You are now released.
Thank you very much, Honorable CJ and the Honorable Commissioners.